What's going on, you guys? Welcome to another episode of All Things Labeler. And today we're going to talk about the issue of dismissal. What is a dismissal? And everything in relation to what a dismissal is. Now, before I continue, don't forget to like and subscribe to my channel, where you'll find always the relevant content in relation to literally everything relating to labor law. Somebody asked me the other day, how much do I pay for subscription? Guys, it's completely free. So dismissal, what is dismissal? Okay, so dismissal is basically, you get three types of dismissal in terms of LRA. Now remember guys, when it comes to our YouTube channel, we always quote things from the legislation. I always quote sections, so you can know I'm not speaking out of turn or I'm making things up. I quote direct from the legislation so that you can be able, you guys can be able to understand where all these things are coming from. So I'm just basically giving you an overview of labor law. I don't really go much into detail unless you specifically ask me to go into detail. So this is just basically labor law 101, right? So dismissal, basically you get three types of dismissals. Is a dismissal for misconduct, where you do something wrong, or you get the dismissal for operational requirements if the employer no longer needs your services, and that is basically a no-fault dismissal. It's not your fault that you get dismissed, and normally it's technological or economic reasons to why the employee dismiss you for operational requirements. And another way that you can be dismissed is by due to incapacity. So those are the three types of dismissals. I'm not going to go into detail in relation to that. I'm just basically giving you scenarios in terms of the law as to how you can dismiss. Then there's another aspect of dismissals that is there, and that is in the form of automatically unfair dismissal. Automatically unfair dismissal is also enshrined in the legislation. Perhaps I should quote the legislation. A dismissal you'll find in terms of Section 186 of the Labour Relations Act that talks about dismissal, what must happen in the event of a dismissal. Okay, and then Section 187 talks about a automatically unfair dismissal. You'll notice that I'm not even going to the legislation. These things are ingrained in me. I mean, I work with these things every single day, notwithstanding the fact that I've been drilled in this with this by my professor and my lecturers at the time I was studying. So the things, many of the things that I talk about, it's in my mind, it's ingrained in me already. I know exactly where to go in terms of the legislation, and that is basically what I want for you guys. You guys must be able to know exactly where to go when it comes to any piece of labor legislation. You know what, guys? Another thing as well that I come to realize, all my students, I see your frustration in your comments all the time. I see how frustrated you are, and the frustration for me is a very good sign. It tells me you take on board what I say, and the thing is to learn and you implement and you see these things in the workplace, of which now you see the gross contravention that the employer is doing, and that makes you frustrated, and that's a good thing. So now that you are learning this knowledge, and you have learned this knowledge, my challenge to you guys is that, what are you going to do about the knowledge you learn? You need to implement these things. You need to go to the relevant places to get recourse. You need to follow the internal grievance procedures, things like that. You need to talk to your manager and say, hang on a minute, but I think you're wrong when you did that. Engage, because the things that you're speaking about is from a platform of knowledge, the things that you've learned, acquired. That's why labor laws are there at the end of the day, to protect you, to protect me, to protect everybody at the end of the day. So that's why I'm saying it's always important for you to be able to know what the law is saying in an effort for you to be able to exercise your rights in the workplace. Yes, now I'm going to talk about the burden of proof when it comes to dismissals. Remember, in my previous content that I speak to you guys about, is also about the who bears the onus to proof. If you want to know about the burden of proof, please go check on my previous videos in relation to that. Right. So in terms of a dismissal, the law says that if there's a dispute about who was dismissed, or no, if there's a dispute about if there actually was dismissal, the burden of proof is with you, my friend, who is alleging that there was a dismissal, and that is quite prevalent nowadays, in terms of COVID, in terms of people being laid off for indefinite periods of time, and that is what the CCMA commissions are basically grappling with now, in terms of the burden of proof. The employer will come back and say, "But hang on, I didn't dismiss this guy. He's been laying off," and those are the grey areas in the law that we need to look into. We need to delve into that. We need to see whether there's undue prejudice by the employer. So the law says that if there's a dispute about dismissal, the burden of proof shifts to the employee. Now that's very important. Now, however, if it's a common cause fact that a dismissal was established, the burden of proof shifts to the employer, and he needs to substantiate as to why you were dismissed. And at the CCMA, they only look for two things basically when it comes to a dismissal. They just want to know whether dismissal was procedurally and substantively fair. Okay, that's very critically, fundamentally important. I can't stress that enough. You see, so the burden of proof, and basically in a nutshell, if you think about it, that's basically the only two things that the commission is interested in. Whether you procedurally fairly dismiss, and whether you substantively fair. Now, when I talk about procedure basically means that were you notified that you did something wrong, and was there disciplinary inquiry done by the employer? In terms of, was a disciplinary hearing conducted? Was there a neutral chairperson in the proceedings to ascertain whether you did something wrong? And I always say, when it comes to a disciplinary inquiry a disciplinary inquiry, I do not want you to shy away from that. I want you to embrace it. Actually, I want you to be able to. Because remember, that is a tool or a practice for you to be able to prove that you did not do this, or the employer must prove that you did something wrong. You did do something wrong. Now, in my witness over the years, I don't know, I'm probably not allowed to say that, but you never admit to guilt. You, as my students, you never admit to anything that is guilt that the employer is alleging against you. You never admit your guilt. Because you know the burden of proof rests with the employer. You need to, if the employer asks you in the disciplinary hearing, how do you plead? You best believe that you're going to say you're not guilty, because the burden shifts to the employer to improve whether you did this thing wrong, that you have committed a misconduct. Remember, I spoke about the different types of. Now, in this instance, when it comes to disciplinary inquiry, it falls in line with misconduct. You need to be able to use that platform to be able to defend yourself. And when the disciplinary inquiry takes place, the employer must set out the charges in front of you and give you at least a week or a couple of days before the time, so that you can be familiarized with the charges and prepare adequately. That's in terms of procedural. No? Now, if that process is done and then you find yourself still to be dismissed for misconduct, then the next thing that needs to take place is that you can lodge a dispute at the CCMA, for an unfair dismissal. And then, like I said early on, the commissioner is only there is interested in whether you procedurally and substantively unfairly dismissed. Now, I've dealt with procedure. Now let's talk about substantiveness, in terms of, because section 186 talks about dismissal. All these things I'm mentioning, you're gonna find that in the so go read it up, read up on it. The only way you learn is to start reading legislation. Labor laws, or in fact any type of law, it's not only for lawyers, it's for all of us. We need to start reading up on things, and I challenge you as my students, as the people watching on this program, to start reading up on the things that you learn. And even if you don't know something, go research. Google is easily accessible to anybody, right? Anyway, let's go back to substance. Now, substantiveness is whether you've been unfairly dismissed or whether you've been fairly dismissed. If you can prove to the commissioner that you've been unfairly dismissed, then that speaks to substance. Then yes, indeed, you have been unfairly dismissed. Now, I'm going to wrap up here. I'm not going to go too much. I can talk about this the whole day, but for the sake of time, let me just wrap up here. Let's just pause and let me wrap up. Now, and in conclusion, we're going to talk about remedies. There's basically 3 types of remedies that is available to you. So, when you have proven your case in terms of to the commissioner or to the CCMA that the employer did not procedurally dismiss me unfairly because he didn't even have a hearing. He just said to me, leave my premises, don't come back here again. I don't want you on my premises, and you had to leave without giving you a reason or whatever. There is a reason, but he didn't hold the proper procedure in terms of disciplinary hearing. Now, but indeed, he found that you did maybe perhaps steal this thing or whatever the misconduct is. I'm not going to go to that. Then, if the employer finds or if the commissioner finds that you've been procedurally unfairly dismissed but substantively fairly dismissed, then you only have one remedy. You have the remedy of compensation, and the compensation is going to be determined by the commissioner. In most cases, it's like a 1 month's salary, and that's the end of the case. And there you go. However, if you've been substantively and procedurally unfairly dismissed on both levels, there wasn't a hearing. He just accused you of something and you have no idea what happened, but yet he said, go to my place, and you didn't even know why you've been charged. Or he's falsely accusing you of something that you didn't even do, and you've been unfairly dismissed, Then, and you've proved that to the commissioner in terms of the CCMA, and the commissioner rules in your favor when it comes to arbitration. Remember, that's something I'm going to deal with at a later stage. I'm going to tell you the processes of the CCMA, but that is for another day. In broad terms, there's 2 processes that happens in the CCMA. There's a conciliation process, and if the matter is not resolved in conciliation, it moves over then to the arbitration process. But I'll deal with that at another time. So, yes, anyway, so if the commissioner rules that you have been unfairly dismissed, substantively and procedurally unfairly dismissed, then you have a remedy. Then you can request, because remember, the CCMA is going to ask you, what relief do you seek from us after a ruling, making a determination on this matter? Then you say, no, I want my job back, I didn't do anything wrong. And then the commissioner will rule in your favor in terms of substantively and procedurally. Then the relief that you have is, then you can get something called reinstatement. And even furthermore, you can get retrospective reinstatement if you argue your case very strongly. So which means that retrospective reinstatement means that, okay, you've been dismissed, your case came before the CCMA. However, the matter dragged on for 2 or 3 months, and then the matter was heard. It took another 21 days or 14 days for the commissioner to make his award. Then the time went on, it's been 3 months now. Then you can ask the commissioner, no, commissioner, I've been out of work for the last 3 months. I want to be retrospectively reinstated. So it means that your years of service will continue as normal, and the 3 months you were not working, you're supposed to get your 3 months salary paid, and you go back to your job. That is reinstatement. Or another element is that the commissioner said, yeah, but you did do something, perhaps you did do something wrong, but it didn't warrant dismissal. I'll make a ruling, or I'll make a determination short of dismissal. Something that short of dismissal could be probably re-employment. Re-employment is something where you can, it basically means that you're going to start over at the company. Your years of service is lost, even if you were off for whatever so much. You're not going to get money for that. You're just basically going to go back into the job, and you will start at the bottom, or you will start in that position, but maybe on the lower scale of the spectrum, or you'll just start doing that job again. But at least you have your job back, at least, at the very least. Yeah. So those are the things that you have at your disposal when it comes to dismissal, guys. Is actually very broad. I'm not even going to deal with the issue of incapacity and the issue of operational requirements. That type of dismissals I can deal with at a later stage. But I've just given you a broad overview of the nature of dismissals and what basically it entails. So yes, thank you very much. And don't forget, you will find me on Facebook, All Things Labelo on Facebook, and obviously All Things Labelo on YouTube. You can engage me there. I have a separate email for this YouTube channel. It's called All Things Labor Related @gmail.com, is where you can engage me as well. All my contact details are on my Facebook page if you want to engage me. I'm not far away from me. I'm just basically a click away. So yes, thank you very much, guys, for engaging, and don't forget to share this video, subscribe to the channel to get to cope yourself, and having said that, until next time, goodbye.